Welcome and thank you for standing by for today's conference. All participants will be in listen-only mode until the question and answer session. At that time, to ask a question, please press star 1. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I'd now like to turn the call over to Anthony Sargis. Sir, you may begin.
Thank you, Melinda. Appreciate it. Good afternoon, everyone, and welcome to our GDPR webinar for manufacturers. I'm here with Bill Roberts with Shipman and Goodwin, and I'm going to go over his bio in a second here, and he's going to be presenting on this topic today. We have another webinar next week, specifically GDPR for education, which Bill is also going to be presenting on, and we have a few other topics in the near future coming up. Specifically, we're going to discuss Incoterms 2020 on November 14th. We're going to do a direct line conference call if you're interested in that. And then we have an export docs seminar also scheduled for December 5th in Hartford, Connecticut at the UConn campus. So we'll keep that information coming to you on other events. But as always, I'd like to throw it out there that if there's any other topics that you are interested in us covering, please send me a note and let me know, anthony.sargis@trade.gov, and we'll do our best to reach out to experts that can discuss those topics in detail. Just housekeeping for today. So we have 1 hour with Bill today, and he's going to really go into good detail on GDPR for manufacturers. If you have questions throughout, you can type those questions in, and I'll monitor that Q&A box that should be popping up on the bottom of your screen, and those questions will come directly to me. Or you can hold your questions till the end of the presentation, and we'll address those questions verbally. I'm just going to go through Bill's bio real quick. Bill Roberts is co-chair of the firm's Data, Privacy, and Protection Practice Group and a partner in the firm's Health Law Practice Group. Bill has extensive practical counseling with clients worldwide on all aspects of cyber security protection and incident response, from handling data breaches affecting millions of individuals to helping publicly traded corporations, privately held businesses, and not-for-profit organizations establish compliance programs under the EU's GDPR and related U.S. federal and state data privacy consumer protection regimes. Now I'm going to turn the presentation over to Bill Roberts. Thank you for participating, Bill.
Great. Thank you very much. We're going to, as Anthony mentioned, we're going to spend the next 55 minutes going through GDPR. We have a lot of slides here because, as many of you may be aware, GDPR is an extensive topic. So everyone will be receiving copies of the slides after today's presentation. So what we're going to be spending the next about 55 minutes is going through some of the most important points that manufacturers need to be aware of to determine first if GDPR in fact applies to their organization, and if so, what steps the company should be taking. So we're going to start with a brief overview of what GDPR is. We're going to talk a bit about how it applies to U.S. manufacturers. I think this is really the key take-home point here. And then for those who are or may be subject to it, we're going to spend some time going through a high level of the key compliance obligations and some recommended steps for establishing a GDPR compliance program. So GDPR is short for the General Data Protection Regulation, and this is a European Union law that covers the entire life cycle of personal data. It's collection, use, breach, disclosure, disposal, etc. It's very different than most U.S. privacy laws because it applies to everyone. It's not like HIPAA or Gramm-Leach-Bliley or FERPA or some other U.S. privacy laws that you may have heard of that apply very narrowly to certain sectors, certain types of industries. GDPR applies to everyone. Now, the law came into effect on May 25th, 2018. Now, I know that could give some pause to folks saying, oh, wow, this is, we're already like about a year and a half late. I wouldn't worry about it. Unfortunately, GDPR is very confusing at times is to figure out when it in fact applies. Compliance itself takes a long time, and the most important thing to keep in mind is that if you do need to comply, not to fixate on the date, but really to focus on having an appropriate plan to bring your entity into compliance in a reasonable time frame. So as mentioned, the GDPR governs the entire life cycle of data, and it addresses personal data. So what is personal data? Personal data is an extremely broad term, and there's you'll see on the screen now the two types of data. It is data that relates to someone who is identified, such as someone's name and address, but it also relates to someone who could be identified. So personal data may not give you the person's name, but personal data may exist if you could simply use that data to identify a person or come close to identifying a person. So really the take-home point here is that, again, unlike many U.S. privacy laws, personal data is very broad and could really mean almost anything. The only exception is truly anonymous and truly de-identified data, but as a word of caution, it's sometimes extremely difficult to know when your data is anonymous and when it's not. It's very, very difficult. So it's truly anonymous data. So the very, very hard standard to be meeting. First, the GDPR, as I mentioned, was a EU privacy law, and it applies to the personal data of individuals located in the European Union. The law is not citizenship-based. When GDPR came out, there was a lot of incorrect guidance in the U.S. media. There have been articles and presentations talking about how GDPR protects the personal data of EU citizens. That is not necessarily correct. It applies to the personal data and protects the personal data of individuals of any citizenship if they are physically located, physically present in the European Union. So what does that mean? That means if an Italian citizen is buying a hot dog in Boston and provides some personal data, maybe drops a business card into a fishbowl to win a free hot dog, GDPR does not apply. However, if I, as an American citizen, go to Italy and the hotel collects my name and billing address, GDPR does apply. It applies based upon location, not based upon citizenship. So those are some of the key terms here, and what I kind of wanted to sum it up is that GDPR, personal data, very, very broad, of individuals located in Europe. That, though, raises the question of why are U.S. companies worried about this, and why should they be worried about it? And we're going to spend a lot of time now going into the application of GDPR, exactly how this European Union law could apply to U.S. companies, and how, and some of the things you should be thinking about when determining if GDPR in fact applies to your own organization. So generally speaking, there are two ways in which a manufacturer may find itself subject to GDPR when handling, again, the personal data of EU residents, people located physically present in the European Union. The first is having an establishment, which we'll talk about, and the second is targeting data subjects in the EU. I can't stress enough that these are not clear-cut tests. We're going to dive into both of these and also provide examples. But each manufacturer must be looked at individually with all the facts and circumstances considered. There is not, again, a clear-cut application to certain types of entities, so you do need to be taking that analysis into account. The first way in which a manufacturer may be subject to GDPR is having an establishment. So I put a quote here from the actual GDPR, but really what this means is that a non-EU manufacturer, such as a manufacturer located in New Hampshire, has an establishment in the European Union, it may, and the key here is may be subject to GDPR. So if you think your company may have an establishment, what are the questions you need to be asking? First is, does the U.S. company have what's called stable arrangements in the European Union? It's a very low standard, no minimum threshold. But you must have some ongoing and you must have some consistent activity, business activity in Europe. So the presence of a single employee, a single agent operating in the European Union. A good example is that maybe you have a remote worker from France, and that person is handling some of your quality control. If you have 10,000 employees in Hartford, Connecticut, and you have one in France, that alone is a stable arrangement. There's no minimum threshold. That single employee may, at least for this part, get you over this first hurdle for compliance with GDPR. The second thing, though, is that the personal data of EU residents that you're processing needs to be somewhat related to that stable arrangement. There needs to be some sort of nexus to it. And I think the easiest way to explain that is through examples. So the stable arrangement test. A manufacturer operating a distribution center in France, that's easy. Yes, you do have a stable arrangement. A manufacturer attends a one-time trade show in France? No, that would probably not meet the test for a stable arrangement because it's not necessarily stable. It's not long-term. There's no duration to it. Maybe you had one employee in France at this conference for 1 hour. It's not a long-term or even medium-term arrangement. Then the relates to processing is a tricky one, but in this case, if the manufacturer with this distribution center in France is processing the personal data of employees working there, then yes, you have a distribution center in France, and you're actually processing the personal data of individuals located in the EU in relation to that. They're the people who are actually working there. The processing you have, the data you have relates back to that distribution center. But it's very different than the manufacturer is processing data of EU residents as part of a contract with the United States government. That has nothing to do with your distribution center, or it has nothing to do with any arrangement you may or may not have in Europe. So it's very possible here that because your processing of data has nothing to do with any, quote, stable arrangement, any activity you're doing in Europe, that processing of EU data alone may not, in fact, make you subject to GDPR. So hopefully these examples will give you something to be thinking about. And then I would really focus on the stable arrangement piece of this. Do you have an office in the European Union? Do you have a factory? Do you have remote workers? Do you have employees? Do you have sales reps who may spend 3 months a year in Europe? Do you have a regular schedule of activity where your sales reps are perhaps visiting your EU-based customers? Every 12 months they're visiting a customer in Germany, for example. Do you have regular attendance at certain events? Do you sponsor a conference every 6 months in Frankfurt? Any of those regular activities at least should raise the question of, do we have that stable arrangement? Now, if you conduct an analysis of this establishment part and you find that you don't have a stable arrangement, you have nothing, you don't have a single employee in Europe, you have no activity, no boots on the ground there, no offices, no factories, nothing. Or the processing you do has nothing to do with any of your activities in Europe. You work with your counsel and you say, you know what, we don't have an establishment. That's only the first step. You then need to look at the targeting approach to GDPR. Because a manufacturer, even if they have no establishment in Europe, may nevertheless become subject to GDPR if they are, quote, targeting individuals located in the European Union by offering them goods or services or monitoring their behavior. The key points here is that goods and services is defined very broadly and no need for payment. Offering someone goods or services doesn't mean the same thing as making a sale or selling things. You may be offering a service for free. It may not even be what you could consider a typical service. Now, in the manufacturing context, it's a little simpler because most of what we're dealing with are traditionally viewed as goods or services. But it gets tricky in other areas such as healthcare or education, where you may not necessarily view an online calculus class as a service. Now, these are all things that a U.S. manufacturer should be thinking about when it's determining if it's in fact targeting goods or services to EU individuals. And I'm going to spend some time on this slide because for those entities who do not have an establishment in Europe, this is really probably the most important slide of this presentation in terms of whether GDPR applies to your entity. The first is you want to look at your marketing materials. You want to look at your website, maybe some pamphlets or sales documents, and look to see if an EU or a member state, meaning one of the countries, such as France or Spain, is mentioned by name. So that's a sign that maybe you are in fact targeting your goods or services to individuals located in Europe. And I have an example here. Quote, encouraging all French aerospace companies to check out our informational brochure. That would suggest to a government regulator that you are in fact targeting the offer of your products to individuals in Europe. The second thing is your advertising. Not so much the content of your materials, but also by how you are displaying those. Where do you run your ads? Are your ads geofenced to the U.S. and Canada only, or are you running online ads in Europe? Are you focusing your marketing maybe perhaps on trade shows in Europe where you're passing out widgets and you're passing out tchotchkes of all sorts of wristbands and pens and hats? A dedicated address or phone number. For if you have a website which says, you know, call our company and here's our Connecticut area code, that's very different than an advertisement which says, if you're from the Netherlands, here's our Dutch number. Use of a top-level domain. So that's, for example, something different than .com or .org. You may use a .de for Germany, or .eu for maybe a European Union-wide website. The mention of an international customer base or testimonials. So if your marketing materials were to have a blurb about how a company in Italy loves your products, that would be important to know. Use of an EU language. Generally, that would mean any language other than English, perhaps Spanish, and perhaps Portuguese as well. But if it's a language such as German or Dutch, which is primarily spoken only in the European Union, that would be very indicative of targeting EU residents. And the last is accepting payment in euros. Now, it's important to keep in mind that just one of these alone may or may not be enough to bring you under GDPR. It's really the facts and circumstances approach that you need to be looking at. The other aspect is not only targeting for goods or services, but this is this is somewhat less common for manufacturers, but we still have seen some become subject to GDPR due to this monitoring the behavior of EU residents, such as tracking online activity, monitoring health status or health events, tracking opinions, monitoring travel choices, online shopping choices. If you're doing any of those things and it's involving the personal data of someone in Europe, you may be subject to GDPR as well. So here are some examples that sort of highlight the targeting of the goods and services. The first element is the person located in the European Union? A U.S. manufacturer receives inquiries from potential customers in France. Yes, that person is. Second is a U.S. manufacturer records demographic information about a visitor from Italy during a facility tour in New York. No, that person is not in the European Union, despite their Italian citizenship. Targeting. A U.S. manufacturer receives an inquiry from potential customers in France? No. The fact that someone contacts you doesn't mean you're subject to GDPR. You're subject to GDPR because of what your company does, not based upon what someone in Europe does. And that's a really important point to keep in mind. It's about what your company is doing, not what someone else is sending you. That's quite different than the last bullet point here, which is you receive an inquiry from a potential customer in France after your company directs its online advertising to the French public in the French language. That's a very different story because you're taking affirmative steps to offer goods or services, and then that person in France is contacting you, sending their personal data to you. Just a quick note here, for those of you who are involved with GDPR or who have been reading about it, two terms you'll often see talked about in the context of application are a controller or a processor. Now, I don't want to spend too much time on the legalese here, but I think it's important to at least mention these two terms. So everyone in GDPR generally is either a controller or a processor or a sub-processor. But let's just group all of those together. So you have controllers, which are the entities making the decisions about personal data. Generally, it's the consumer-facing or customer-facing entity. The processor is the party responsible for processing the data. It's best to think of the processor as the behind-the-scenes vendor. A manufacturer could be either. It could be you may be the controller. You may, if you're actually collecting personal data, you're outreaching to the public, you have a direct consumer focus. You also may be the processor if you're really the vendor for someone else. You could also be both at the same time, but that's certainly a more unusual fact pattern. So it's really just important for the purposes of today's presentation to kind of keep these two things in mind, because if you go through the establishment test and the targeting test, you find out that you are in fact subject to GDPR, your company may be one or both of these categories. We're going to move on now to what the GDPR in fact requires of companies. So if you go through all of the application tests and you determine that you do need to comply with GDPR, what does that mean? The number of requirements for GDPR are extensive, and we're going to cover some of the key ones. But before we do, we're going to talk a bit about more of the general policy behind the GDPR and what's referred to as its principles. So unlike most U.S. laws in the privacy context, GDPR is not a prescriptive law. And what I mean by that, it doesn't necessarily tell a U.S. manufacturer what it may do and what it may not do with personal data. Instead, it says you can almost do anything you want with personal data as long as it is consistent with 7 general principles. So you're not going to find something in GDPR where it's saying a U.S. manufacturer may not do X, Y, and Z. Instead, you're going to find tremendous amounts of guidance on that, which is explaining these principles that a U.S. company needs to be complying with. In some ways, this principle-based focus really gives companies a lot more flexibility to design data privacy programs, to process personal data, to collect personal data. But at the same time, it does require a more thoughtful approach to privacy than many U.S. companies are familiar with. And we're going to spend a brief amount of time covering each of these to give those on the call a sense of what exactly GDPR expects of U.S. companies. The first general principle that the use of the data needs to be lawful. You need to be collecting and receiving the data in a manner consistent with GDPR. But the most important point here seems sort of obvious, I think, but I really wanted to highlight it, is that your use of and collection of data cannot be unexpected or misleading, and that you need to be clear, open, and honest with the individuals. So that when you are collecting data, you need to make sure you're being transparent about it so that the user knows their data is being collected and they know how and why. The why portion of it speaks to the idea of a purpose, is that you must have a clear purpose for the processing of personal data, and that must be documented. The trickiest part for U.S. firms is the last bullet point, where if you collect personal data for one purpose, you cannot necessarily use it for a separate, unrelated purpose. And that's really important to keep in mind, is that the data you collect and use is linked to this purpose. So everything you're doing with it needs to be consistent with that principle. The next principle is a little more familiar to U.S. companies, particularly those in the healthcare space, in terms of pharma or device companies. To limit your data to what is necessary. The data you collect, it must be relevant to your purpose. If you have a particular data collection program and you ask for 20 bits of data from a person, you need to make sure that those 20 bits of data are actually relevant to what you're using it for. If you're selling someone a particular product, you may need to know their height and weight, but you don't necessarily need to know their hair color. So you always want to be asking, and this is throughout GDPR, why am I collecting this data, and do I really need to? The next principle is accuracy. So a manufacturer must take reasonable steps to ensure the information it holds is correct and not misleading. There's also the obligation at times to keep the information current and correct erroneous data. When you're thinking about this standard and when you need to keep data current, when you need to update data, when you need to fix data, you want to be thinking about, if I don't fix this data, if I don't keep this data current, will an individual who I'm collecting the data from be harmed? Will I not be able to provide the proper service? Will they be impacted in some adverse manner? In a very, very broad sense, if I don't take some steps to keep their registration with me, for example, current, if I'm monitoring their health status, if I have a healthcare product, and if I don't keep their weight current, will that impact their use of my device? That's just one example. So you want to always be thinking about what kind of harms may in fact come from a failure to keep this data current. Storage is the next principle, and this really speaks to data retention. Any company subject to GDPR needs to have a personal data retention schedule. GDPR, again, getting back to the concept that it's not a prescriptive law, doesn't tell you what that retention schedule needs to be. It doesn't give you 7 years, it doesn't give you 10 years, it doesn't give you 3 months. The personal data retention schedule will likely differ for any company because each schedule will need to be unique to your own circumstances, your own business needs, and your own legal obligations. The second to last principle is security. And I just want to, for this point here, I just want to focus on the idea that GDPR is a privacy law. It's not an IT law. It's not a cybersecurity law. GDPR gives you all these principles of how you should collect and use personal data. It does not go into specific requirements for cybersecurity. However, you do need to keep in mind the general principle that if you have personal data, you need to take reasonable steps to safeguard it. The last principle for GDPR compliance is accountability. And I saved this principle for the end because it's certainly the most loaded one. There's a lot to unpack with accountability, and we're going to spend several slides doing it. Accountability is where most of the most well-known GDPR requirements, such as privacy by design and breach reporting, most of these requirements stem from the accountability principle. But the most fundamental aspect of accountability is that compliance with GDPR is not enough. You need to be able to evidence that compliance. You could tell a regulator all day that you have this wonderful breach program, that you have a data retention schedule, that you meet the purpose principle. But if you don't have documentation of it, that's not going to be sufficient. GDPR is very clear that it requires you both to comply with GDPR and to evidence that compliance. And that really speaks to the notion of documenting everything. Document your purpose. Document why you have the purpose. Document what your data retention schedule is, and document why you picked 6 years rather than 7 years, for example. So we're going to go through a couple aspects here of the types of issues, like I said, that arise from the accountability principle. The first is privacy by design. And this is a term that's tossed around quite a bit, but it is probably of most importance in the manufacturing space. The GDPR requires manufacturers to put in place appropriate measures to implement the data protection principles that we've been talking about, so transparency and lawfulness and purpose and security as a fundamental baked-in aspect of product development. GDPR does not allow manufacturers to treat data privacy as an afterthought. It needs to be a core consideration from the moment of the first sketches. The and it needs to be part of all decision-making going forward. So when you're designing a product, when you're designing a service, privacy needs to be addressed anytime personal data is discussed or collected as part of that service. So if your company is a manufacturer of sensors, you can't build the sensor, you can't design the sensor, and then after the fact call an attorney and say, I wonder what the privacy implications are about this. You need to, from the very beginning of developing that sensor, have privacy as a core value when building this product and designing it. And a part of that means treating privacy as the default standard and have personal data automatically protected. So what this means is that an individual should not have to take any specific action to protect their privacy. So let's go back to the sensor example. When you're developing your sensor, maybe there's an option, maybe that you have an app that goes along with it, and one of your engineering team members says, we could give an option in the app that someone could object to the sensor sending back images of the people it records back to the company for research purposes. Let's give someone the right to object to that. GDPR does not allow that. GDPR says privacy needs to be the default. So you can't have the default be we take all of your data for our own purposes and you have a right to opt out. The default needs to be the automatic setting, out of the box setting is on the most private possible, and then give people the right to share their data, not a right to opt out of sharing their data. And of course, all of this needs to be considered with the other principles. Are you being transparent about your collection of data? Are you being transparent about the rights you're giving to people to object to that data or to allow the sharing? Are you securing the data when you're sharing it? So all of these principles are all sort of baked into this privacy by design concept that need to be addressed. Another accountability principle is vendor contracting. So you're not only responsible for how you comply with GDPR. If you turn around and give the personal data to a third-party vendor, you also need to be accountable for how they process it. And that is something many of you may have seen, the data processing agreements or addendum, it's called both. These DPAs are really the contracts used for your vendors to ensure that they are complying with GDPR just like you are. The last accountability principle I wanted to address here is breach reporting. This is only, again, one of many, many aspects of GDPR. It probably gets the most press because of 72 hours, very rapid turnaround. And for U.S. companies, this can be very new unless you're in the finance or insurance space. They're probably the only sectors that are used to such rapid turnarounds. Some defense contracts as well, though. The take-home here is that GDPR requires a robust breach detection, investigation, reporting procedure. And unless you have that, it's almost impossible to actually meet the 72-hour deadline. So what we're going to turn to now is how to go about doing this. So we're going to spend the rest of this of our time together here going through a sample compliance program of how to go about doing it. What are the steps? So we covered who needs to apply with it. If you need to comply, you need to understand the principles that actually are the basis and the foundation for compliance. But all of this is likely seeming like a lot. So we really wanted to end today with an outline of what are the steps a manufacturer should be taking to actually develop a GDPR compliant operation. The key here is that it's a marathon, not a sprint. It takes a long time to become GDPR compliant in most cases. Some entities are fairly straightforward, but you should really be focused on the long game here and not a quick sprint. The most fundamental and the most important step of GDPR compliance is your data review and inventory. Everything you do flows from this, and it's really the basis for your entire program. This is the step which is sometimes takes the longest, is actually looking at your business and asking detailed, hard questions about when are we receiving GDPR personal data, when are we collecting it, which departments have it, how are we getting it, all those ways, because you can't design a compliant GDPR program to protect your personal data unless you know where that personal data is and how you're actually getting it. Now, you should consider both your controller style function, so when you're actually getting data directly from someone, but also your processor functions. You cannot always rely upon your customers to send you the DPA contract, which I mentioned a few minutes ago. You do need to be thinking about, you know what, we may be a processor here. We should take the initiative and determine that for ourselves so that we can be compliant when our customers come knocking. The second is the identification of data processors. This is really closely related with your data review and inventory. So during the data review, you're looking at all of the data you have, where it's located, how it's used, where you're getting it from. Part of that needs to be, okay, we have all of this data. We understand where it's coming from, how we're using it, but who are we then in turn redisclosing that data to? Who are the vendors who are getting our personal data? Some of the common ones could be email services, your data backup vendors, your HR vendors, cloud storage companies. So I'll give you an example of probably the most common is if you have an establishment in the European Union. Let's go back to that distribution center in France, or that lone remote worker in France. You may be processing that person's, all the employees' data, the remote worker or the distribution center workers, and then you may take the data from them, their tax data, their employment data, their performance evaluations, their salary info, their home address, all of that. And then you may turn around and send that to your own HR vendor for processing. You need to ensure that you identify who you're sending the European Union personal data to, and make sure you have a data processing agreement with them. And the second bullet point on this slide kind of goes through the questions you should be asking. So for this HR vendor of yours, what is the subject matter? Why are we sending? What is this all about? It's for HR. What is the duration? Maybe as long as the employee is working for us, perhaps. Nature and purpose, maybe to process benefits or handle payroll, or simply to store the data. You need to know the types of data you're sending to this HR vendor. Maybe you're, like I said, you're sending all the payroll data, but you're not actually, you don't need to send the performance evaluation data. That kind of gets back to the principles we were talking about. Do I really need to collect this data? Do I really need to send it? You always need to be aware of what's called these special categories of data. So the GDPR has sort of calls out very sensitive types of data, such as data regarding religious faith or union membership, healthcare. Am I sending those as well to this vendor? You need to identify that and know whether you're in fact sending it. And then the categories. Generally, is it employee data or customer data? So it's a lot more involved than simply identifying a vendor. You do need to ask all of these questions for each one. And again, getting back to that concept of evidence, you need to document all of it. The next step for GDPR compliance program is having a policy manual. So much of what you do for GDPR, once the program is up and running, the day-to-day things, GDPR has a whole host of individual rights. I'm sure many of you have heard about the right to be forgotten. How do you handle that? You need a policy on it. You need a policy on breaches. You need a policy on consents, and how are you going to handle privacy by design? What is your record retention schedule? The simplest way to evidence all of this is a cohesive single GDPR privacy policy manual, which really is the book to be looking at anytime there's a GDPR question, and should something happen, there'll be a breach, a complaint, you can present that manual as the evidence that your company not only complies with GDPR, but you are evidencing that compliance and you're taking it very seriously. The next step when you are complying with GDPR is that once you have this manual, you likely have a whole bunch of other privacy notices and existing policies. You may have some IT policies. Privacy may be referenced in an HR policy. You do need to make sure that your existing policies also conform to GDPR. You can't just have the manual say one thing and your HR manual, you can't have the GDPR manual say one thing, your HR manual say something different. There needs to be cohesion for that. And you also need to be thinking about the proper notices, or your current notices, your cookie banner perhaps. Are all of those consistent with your GDPR compliance requirements and your compliance program? You may need what's called a data protection officer. And I say may because sometimes you could actually combine that role with an existing staff person. The core, though, is that you do need to appoint someone at your organization to be responsible for GDPR. Sometimes it is a standalone data protection officer, particularly for larger companies. Sometimes you may want to make your current privacy officer or compliance staff handle it. If you have a large EU presence, an establishment, for example, it may make sense to have an EU-based data protection officer, or to even outsource it. It really is a company-by-company determination, but depending upon your exposure to GDPR, depending upon your internal resources, it may be something that you actually locate in Europe or use a third-party consultant to be handling. Training. You can have all the policies in the world. You can have the greatest breach policy ever drafted. But if your employees are not trained on it, it's not worth very much. When you're designing a GDPR training program, it is good to be specific. Not all of your employees need to know everything about GDPR. Instead, think about who are the employees that need to be trained, who are the ones with potential access to GDPR, who are the ones who are handling requests from EU residents regarding the right to be forgotten or right to access of their data. Who are the people who would be in a position to find out about a breach? And that really speaks to the idea that not everyone needs to be trained on everything. People at your company may have different roles, different exposure to GDPR, and it's most important to focus training to empower that person to be able to fulfill their GDPR duties. What you also want to be thinking about, though, is ongoing awareness of GDPR. So whether one training might be for IT, another might be for HR. Even people who have an ancillary relationship to your GDPR program or to your data still need to be aware of it so that they can issue spot. Know when GDPR might be a problem, know when to ask questions, and most importantly, know who to call for those questions. The next item and last item for GDPR compliance program, the next step, is consider whether you need what's called a data representative. This is a role primarily for companies that either have a fairly meaningful EU establishment or who process a large amount of personal data. This is someone, the data representative is someone who is in Europe, so it's often an EU-based attorney, consultant, or other privacy professional who can be your representative when there's questions from either European Union or member state regulators. So it's a person to call. It's a person to ask questions to. It's a person to represent your interests. Again, not everyone needs this, but it is something to think about if you are either have a lot of personal data or a fairly significant presence in the European Union. Now, I want to do a quick note on GDPR as a competitive edge, because all we've been talking about is obligations and obligations and more obligations. We've also been talking about things which, of course, take a lot of time and cost money to be doing. And one thing our clients have, I think, done very wisely when possible is to use GDPR compliance as a marketing tool. So you may have a small exposure to GDPR. You may almost have no exposure, but you may have plans in 3 years to enter the European Union market or open a location in Brussels, for example. Many companies in the United States are not subject to GDPR. And until more are, being compliant with GDPR is a way to look at the European Union market and address the concerns of European companies and vendors and customers to position yourself as a U.S. company that they can do business with safely. If you're going to be spending all of this time and money to comply with GDPR, you might as well make people know about it. Make sure your sales team is aware of your GDPR compliance. Look to having a GDPR mini site, which is something we've done quite a bit. Address GDPR in your customer-facing materials or resources, whether that's a letter from your CEO or FAQs. Really take this investment and try to get some more mileage out of it, because it's a lot of time and money, and you do want to make sure that your potential business partners are aware of the investment you have made in data privacy. So a few parting thoughts. We have about 1 minute to go until we open things up to questions. But I just want to end on a few lessons learned from doing GDPR work these last few years. And the first is the most important. GDPR is not an IT task. It is not something you send to the IT department or to your data security department to handle. While they need to be at the table, and as mentioned earlier, GDPR is a privacy law, not a security law. GDPR can only be handled with a large and diverse group of internal stakeholders at the table. IT is just simply one of them. You want to be looking at HR, procurement, shipping, sales, and marketing. All of those have just as much of a role to play as IT. And now this isn't to focus on one department more than the other, but it's simply to acknowledge that this is not the kind of project that you could just simply hand to the IT department and say, best of luck, because there's only so much that department can be doing. The internal working group of all stakeholders is vital. You need to spend as much time take as much time as you need to focus on the data inventory. Far too often, companies want to rush through that step. And the problem with doing that is that all the policies, all the procedures, all the contracts you do afterwards is all based upon what you find out during the inventory. So you really need to get that right. Take your time, come up with a schedule, and not rush through that. The next bit of advice is document everything. If you don't document it, it's like it never happened. It's not going to be of any use to you should you be audited by a customer or investigated by a government agency. And then the last point, which I've mentioned a few times here, I think, is that GDPR's long-term strategy and a cultural change. It's not a quick fix. I think the privacy by design concept really hits home there, where it does need to change how your company operates and how you're doing business with respect to personal data, rather than just simply doing something a bit differently in a short period of time. So with that, we have about 3 minutes for questions.
All right, Bill. Thank you so much
Anthony,
for that.
Do you have any?
I'm gonna ask the operator to open it up for questions, and then while we wait for questions, I'll make a couple remarks.
Thank you. And at this time, to ask your question, please press *1. Please unmute your phone and record your name clearly at the prompt. Once again, to ask a question, please press *1 at this time. One moment, please, for any questions.
Thank you. Yeah, well, thank you, Bill, so much for doing this. I mean, I've seen a couple of these presentations over, I guess, the last year and a half or so, maybe, since May of 2018, and definitely a lot of misconceptions, I think anecdotal information that has floated around out there, and I think some of those things you addressed today, because I think there's just more information available now that the regulation's been in place. So we really thank you for discussing that today. I saw Jackie Torsolini had a question. I don't know if she's still on.
Yeah, while we're waiting for questions, though, just to your point, Anthony, about changes to misconceptions. Since May 25th, 2018, there has been a tremendous amount of guidance published by the European Union, by the Information Commissioner's Office in the UK, all of which has really helped to clarify, particularly the application. I think the most recent document from the European Union on application alone gives dozens of examples. There's probably 30 pages of guidance to help companies. So there has been a tremendous amount of guidance really coming out about this law. So whatever you've learned in May 25th, 2018 is very different now, and we expect that to continue over the next several years as more and more guidance is published.
That's great. Thank you. Thank you, Bill. Operator, do we have any questions?
Thank you. We do. Jackie, your line is open at this time.
Hey, Jackie,
hi, good afternoon. I'm good, thanks. Thank you for the information today. Very interesting. And my question was, if there's a company and they're working with a distributor in the European Union, they're selling products in the European Union, but they're by chance not collecting individual customer data here in the United States, or in the instance, what if their distributor or their sales representative group says that they're in compliance with GDPR but is not, and can something reach back to the U.S. company if a partner's compliant?
So as long as the U.S. company itself is not subject to GDPR, the European Union will not have jurisdiction over that. So as long as there's no as long as that personal data is not then being passed back to you, that's the first thing. At that point, it's possible you would not be subject to GDPR. The only potential wrinkle here is I could see hypothetically at least that if the U.S. company is directing the EU distributor regarding what to collect and how to collect it, the U.S. company may be a data controller. But I think in your example, the fact that the data never comes back to the U.S., I think that would make the U.S. company protected.
Okay. And what about, so say the U.S. company has, they're conforming with GDPR, but the sales representative group or distributor group that they've hired abroad is not.
Okay. So, yeah, that is a much more serious problem. So if the U.S. company is subject to GDPR, in that case it would likely be the data controller. A company subject to GDPR is accountable for what it does with the personal data, and it's accountable for what its vendors do. So if the U.S. company is a data controller, goes to Europe, hires a third-party company, and knows that that third-party company is not complying with GDPR, despite the data processing agreement in place, despite the law, the data controller then needs to be taking steps to either remedy that non-compliance or use a different vendor.
Okay.
All right. Thank you, Jackie. Thanks for the question.
Sure.
Operator, do we have any other questions?
We are showing no further questions.
All right. Thank you, Bill, for the presentation today. It was really insightful. I think there's a lot of misconceptions out there, and I think you ironed out a few of those. Thank you, everyone, for joining us today. Again, I will send out the slide deck tomorrow morning. First thing, we'll get the slide deck out to everyone. And if you have further questions, you have Bill's information right on the screen there, and I will include that in my email as well. Thank you, Bill, and thank you.
All right, thank you.
Shipman and Goodwin.
Thank you once again. That does conclude today's conference. We do appreciate attending. You may disconnect at this time.